News just in. In Florida, surviving a self-defense encounter is just the initial victory. The real story unfolds in the crucial second battle, the aftermath.
That's right.
Today, we're diving deep into this often overlooked chapter for armed civilians in the Sunshine State.
Yeah, think of this as a kind of special report. We're focusing on what happens, the moment the threat is neutralized, analyzing the potential legal minefields, the possibility of civil action, and the significant emotional currents that follow.
Our main source for this crucial info is the article, Florida Self-Defense Aftermath, Guidance for Armed Civilians, by Herfel, who's a highly respected firearms instructor. So consider this deep dive your rapid briefing. We want to deliver the essential insights, maybe some surprising realities about this complex area, all without getting bogged down in dense legal text.
Right.
Whether you carry responsibly or you're just interested in understanding self-defense law, this is information you really need to process.
Because, as Herfel's guidance makes clear right from the start, surviving the immediate danger is, well, paramount, obviously. But the subsequent hours, days, even years, they can present their own really formidable challenges.
Like finding yourself under legal scrutiny.
Exactly. Or facing a civil lawsuit and grappling with some pretty profound emotional repercussions.
Okay, let's get straight to the scene then. The article highlights the immediate aftermath, those critical first moments. And the advice seems stark. Win the race to 911. Why is that initial call so vital?
Well, think of that first call as framing the narrative for the responding authorities.
Oh.
By immediately calling 911 and clearly saying you're the victim of an attack, you're proactively establishing your side of the event, before law enforcement even arrives.
So what do you say?
When you make that call, give your exact location. State unequivocally you were the victim of a crime, you were attacked. Request immediate police and ambulance assistance, even if the assailant seems injured.
But the article also warns pretty strongly against oversharing at this point. What should you avoid saying?
Keep it brief, factual, stick to the essentials. I was attacked. I had to defend myself. Please send police and an ambulance to my location. Something like that. Then hang up.
Resist the urge to explain everything.
Definitely. Resist any urge to give lengthy explanations or vent anger or speculate. Remember, that call, it's recorded. It can absolutely be used as evidence later on.
So you've made that crucial 911 call. Adrenaline's probably still sky high. Flashing lights appear. What's the next critical move? How do you ensure you're seen correctly by the police?
Okay, the guidance really stresses your behavior when they arrive. You have to understand, officers showing up won't immediately know who's who. Victim, aggressor, it's chaotic.
Right, their priority is safety.
Their priority is securing the area, making sure everyone's safe. So as the armed civilian, you need to immediately ensure you are not perceived as a continuing threat.
How do you do that?
If it's safe, secure your firearm. Holster it, or maybe carefully place it on the ground. And keep your hands visibly raised. Be prepared to comply with any commands they give. That might mean being ordered to the ground, maybe even temporarily handcuffed.
Why such a seemingly drastic initial response from them?
It's just protocol, officer safety. They're walking into a potentially volatile situation, right? They need to quickly assess and control everyone involved. The article explicitly says, do not resist or argue.
Just cooperate.
Cooperate fully. Point out evidence, witnesses if you can, but avoid debates or offering unsolicited explanations right then. Your firearm, it'll likely be taken as evidence. That's standard procedure.
Okay. Called 911, complying with police.
Yeah.
What specific words should you actually say about the incident itself at that point?
The recommended statement, when they arrive, it's concise and it's crucial. I was attacked and I defended myself because I feared for my life.
That phrase specifically, feared for my life.
Yes. What's vital about that brief statement is it clearly establishes self-defense as the reason for your actions.
And equally important, what not to say.
Don't elaborate. Don't get into the details of the attack or your defensive actions right then. Resist that urge to justify or explain beyond that initial statement. Anything you say, literally anything, can be used against you later in the investigation.
Now, this next bit of advice, it feels counterintuitive to a lot of people, I think. They want to explain their side immediately. But the article strongly advises, after that initial statement, politely decline further questions until your attorney is present.
Correct.
You need to proactively assert your right to remain silent and request a lawyer. Why not just wait for them to read you your Miranda rights?
That's a key distinction, a really common misconception. Miranda rights only apply when you are, 1, in police custody, and 2, being actively interrogated.
So you could say something damaging before that.
Absolutely. You can unknowingly volunteer information that can be used against you, even if you haven't been formally Mirandized. So the advice here is proactive. State you were attacked, acted in fear for your life, then clearly invoke your right to remain silent and explicitly request to speak with your lawyer.
It's interesting, the article notes that even police officers involved in shootings are often advised by their attorneys to wait before giving detailed statements.
That's standard practice for them.
So as a civilian, you should afford yourself that same critical advantage. Get legal counsel immediately. The article points specifically to Florida Statute 776.032. What's the significance there?
That statute is foundational, really key. Florida Statute 776.032 outlines when someone using a lawful self-defense force gets immunity. Immunity from arrest, immunity from criminal prosecution.
So it's the legal basis for protection after the fact.
It's the bedrock, yeah. So having an attorney who knows this statute inside out, who's experienced in Florida self-defense law, it's absolutely critical to make sure your rights under this law are protected right from the get-go.
Okay, let's shift then to understanding the legal landscape itself. Florida's self-defense laws stand your ground. Castle doctrine there key, as the article highlights. Let's start with stand your ground. In simple terms, what does that mean for an armed civilian here?
Essentially, Florida's Stand Your Ground law, mostly in Chapter 776 of the statutes, it removes the old common law duty to retreat before using necessary force, even deadly force.
You don't have to run away first.
Right, if two conditions are met. One, you're not doing anything illegal yourself, and two, you're attacked in a place where you have a lawful right to be, like the street, your workplace, a park.
So meet those conditions, face a credible threat. You don't have to try to escape before defending yourself. But the article stresses the legal review will focus heavily on whether your fear was genuine and reasonable. What does that involve?
The legal assessment, it boils down to whether a reasonable person in the exact same situation would have felt a similar fear, fear of imminent death or great bodily harm.
It's not just your feel.
Not just your subjective feeling, no. It's an objective standard based on the circumstances as they appeared right then. Statutes 776.012 and 776.013 provide the framework for this. They affirm the right to stand your ground, use necessary force under those conditions. And interestingly, the reasonableness isn't always just the immediate moment.
Right.
Well, things like maybe past experiences as a victim or knowing the attacker had a violent history. Those could potentially factor into whether your fear was seen as reasonable. It's complex.
Okay, what about the castle doctrine? How's that different from stand your ground?
The Castle Doctrine, mostly in 776.013, sometimes called the Home Protection Law, gives an even stronger legal presumption, but only in specific places. Your dwelling, your residence, or an occupied vehicle.
Your home, basically. Or your car if you're in it.
Right. If someone forcibly and unlawfully enters one of those places, the law presumes you had a reasonable fear of imminent death or great bodily harm. That presumption justifies using deadly force.
So someone breaks into your house. The legal scales tip heavily in your favor if you use force. And the article mentions a key difference here: no duty to warn or retreat inside your home.
That's correct. The law really recognizes the sanctity of those spaces. But it's crucial to understand, as the article points out, this presumption might not apply if the person you use force against actually had a legal right to be there.
Like a roommate or invited guest.
Exactly. Or maybe even someone who lives there but wasn't supposed to be entering forcibly. So proving the entry was unlawful and unauthorized is still a significant factor. And yeah, dwelling, residence, occupied vehicle. The law can sometimes get technical, but basically think home, maybe a temporary place like a hotel room you're renting, and your car if you're inside. The key is that unlawful, forceful entry. That triggers the presumption.
Now, one of the most significant parts of Florida law, on paper anyway, is this immunity from arrest and prosecution we touched on earlier. How does that actually play out after an incident?
What's critical, and it's right there in 7776.032, is that if you use force legally under Florida's self-defense laws, you are immune from criminal prosecution and from civil lawsuits.
So you shouldn't even be arrested.
In theory, yes. If the evidence strongly supports lawful self-defense, you should not be arrested unless law enforcement has probable cause to believe your use of force was unlawful.
But the article is careful to say this isn't like some automatic magic shield, right? You might still end up in handcuffs, answering questions while they investigate. And there's mention of a potential stand-your-ground immunity hearing. What's that?
Correct. Immunity isn't automatic. Proving you're entitled to it can be a process, stressful. Sometimes before a trial even happens, a judge holds a special hearing, an immunity hearing.
To decide if stand your ground applies.
Exactly. The judge looks at the evidence to see if your actions met the criteria for lawful self-defense under stand your ground or castle doctrine. If the judge rules yes in your favor, the criminal charges are typically dismissed right then and there.
And this immunity also covers civil lawsuits.
It does. That's huge. If your force is deemed lawful, you can't be sued in civil court for damages related to the incident. And sometimes you might even get your attorney's fees covered.
That's a substantial protection against potentially ruinous lawsuits, maybe even ones filed just for retaliation. But the article still advises caution, assumes your actions will be closely looked at.
Absolutely. Never assume just because you believe your actions were lawful that it prevents investigation or even initial detention. Handling that immediate aftermath correctly, making sure the evidence backs up your self-defense claim, those are the crucial steps to actually getting that immunity applied.
Let's circle back quickly to Miranda rights. The article highlighted a really important point about voluntary statements made before being Mirandized.
Yes, that common idea that if they don't read you your rights, nothing counts. That's not quite right. Miranda warnings are only legally required when you're in custody and being interrogated.
So if you just start talking at the scene,
If you voluntarily start talking to officers at the scene before they take you into custody, before they start asking formal questions, those statements, they can absolutely be used against you. No Miranda warning needed for those.
so the smart move is clear. Don't rely on Miranda. Proactively invoke your right to silence and ask for your lawyer after that very brief initial statement about being attacked and fearing for your life.
Precisely. By clearly, politely saying, I'm invoking my right to remain silent, I wish to speak with my lawyer before answering questions, you trigger important legal protections. Law enforcement should stop questioning you at that point.
Okay, to help illustrate how these principles might work together, the article gives an example of a home invasion in Florida. Could you walk us through that and show how the homeowner's actions lined up with the advice?
Certainly. So in this scenario, an armed homeowner, they experience a forceful break-in. They use their firearms, stop the intruder, their immediate action, call 911. On that call, they state clearly, someone broke in, they feared for their life, they had to defend themselves, they request police and medical aid right away.
Then what happens when police arrive?
Following that crucial call, the homeowner secures their firearm, complies fully with every command from the responding deputies. They reiterate calmly, I acted in fear for my life. And they state they'll cooperate fully once their attorney is present. They give ID, don't resist being temporarily detained.
And the investigation.
What's critical here is the investigation backs up the homeowner's story. Evidence confirms the intruder was a stranger, forced entry, maybe used a tool like a crowbar. This triggers that powerful castle doctrine presumption of reasonable fear.
Supporting the self-defense claim.
Strongly supporting it.
Yep.
So because the homeowner followed the steps prompt, 911, secured weapon, brief statement, invoked rights, and because the physical evidence lined up, no criminal charges were filed.
But the article adds an important reminder. Every case is unique. This example isn't a guarantee, right? Personalized legal advice is still essential.
Absolutely vital disclaimer. This scenario shows a positive outcome, sure, but the specific facts, the circumstances, and they vary wildly. The example really just underscores the potential benefits of knowing the law and acting responsibly right after.
Okay, moving beyond the immediate legal steps, the article gets into what it calls the 4 stages of survival. This sounds like a framework to understand the broader journey after the encounter.
Yes, exactly. It emphasizes that surviving the physical fight is just stage 1. There are subsequent battles, equally significant perhaps, the criminal justice fight, the potential civil lawsuit, and crucially, the emotional recovery process.
Stage 1, as we've covered, is the incident itself, physical survival. Goal, stop the threat. But the article notes your actions here heavily impact the later stages.
Precisely. The clearer it is that you had no reasonable alternative but to use force maybe backed by witnesses, security footage, the stronger your position later. Even in that high-stress moment, the prudence, the proportionality of your actions, they get scrutinized carefully afterwards.
Stage 2 is the criminal justice fight. This is where you might be fighting for your freedom, your reputation. The article mentions the investigation, maybe detention or arrest, the huge role of your lawyer, evidence gathering, the prosecutor's decision, maybe pre-trial hearings like that stand your ground immunity hearing, and possibly even a criminal trial.
Yeah, and it's impossible to overstate how vital experienced legal counsel is in this stage. An attorney who specializes in self-defense cases. They guide you, build your defense, find crucial evidence, represent you through everything. That Florida example we talked about, where a judge granted immunity after a stand your ground hearing, that shows a potential positive outcome in this stage, if handled well.
Stage 3 shifts to the civil lawsuit, the possibility of being sued in civil court, even if you're cleared criminally.
Right. And the article explains in civil court, the standard of proof is lower than in criminal court. Easier for someone to win a case against you.
A lower bar to clear.
A lower bar, exactly. But Florida's stand your ground immunity extends to civil actions too. If it's legally determined your force was lawful, that acts as a complete defense against a civil suit. It can get dismissed. You might even recover legal fees, as we said.
So criminal court is beyond a reasonable doubt, very high standard. Civil is just more likely than not.
That's the gist of it, yeah. Preponderance of the evidence, much lower threshold.
But even with that legal protection, the article still cautions about the potentially massive costs of defending a civil suit. And it suggests looking into self-defense insurance.
That's a practical point, because even if you ultimately win and get immunity confirmed, the process itself, discovery, depositions, potential trial before dismissal, can be incredibly complex, time-consuming, and financially draining. Insurance can help manage that financial risk. The Florida example of a civil suit being dismissed due to immunity again shows the strength of the law, but getting there costs money.
Okay, finally, stage 4. This addresses the often overlooked but really critical part, emotional and psychological recovery. The article stresses this can be a long, tough journey, even after a shooting deemed legally justified.
This stage acknowledges the whole spectrum of powerful emotions someone might feel after defending themselves. Relief, sure, but also shock, maybe guilt, anxiety, even symptoms of PTSD.
Post-traumatic stress disorder.
Yes. The article strongly encourages seeking professional help counseling, support groups, connecting with family, community. It also mentions the Florida Attorney General's Victim Services Program as a possible resource.
Yeah.
And, in my experience talking with folks who've been through this, the legal fight itself, it can feel like a second trauma piled on top of the first life-threatening event.
Wow. That's a vital reminder. Even when you're legally in the clear, the emotional toll can be huge. The article stresses self-care, allowing time to heal, and even finding potential for growth or reflection later. And it connects this back to Florida, saying maybe quicker legal resolutions here could allow an earlier focus on healing.
That's a potential benefit of the strong legal framework, yeah.
Mm.
If the legal side resolves more predictably or quickly due to things like immunity hearings, it might free up emotional bandwidth sooner to focus on recovery. But the core point is, emotional recovery is the crucial final step to really reclaim your life after something like this.
So you need to prepare for that too.
Just like you train for the physical and legal aspects, being prepared to address the potential emotional and psychological impact is absolutely vital. It's part of the whole picture.
So bringing all this critical information together, the central takeaway for you, our listener, seems to be that comprehensive preparation for the aftermath, legal, civil, and emotional, is just as essential as being proficient with your firearm.
And as Herfel's article really underscores, getting personalized legal advice from an attorney who specializes in self-defense law in Florida, that's paramount. What we've discussed today is a crucial overview, but it's definitely not a substitute for tailored legal counsel for your specific situation.
The article also strongly encourages seeking out comprehensive firearms training that includes legal education, post-incident protocols. It mentions ValorTech as an example of that kind of well-rounded training.
Right.
This type of training helps you know what to say, maybe more importantly what not to say, and how to make critical calls under intense stress, all within Florida's legal framework.
That holistic approach is key. Combining marksmanship, yes, but also understanding the law, making good decisions under pressure, and knowing exactly what to do after. That's what truly empowers responsible armed citizens to navigate the whole complexity of self-defense.
So as you reflect on this, maybe consider this thought. If you are committed, prepared to defend your life against a deadly threat, are you equally prepared to defend your freedom and maybe your peace of mind in those critical moments and the potentially challenging months that will inevitably follow?
It's about embracing that full spectrum of responsibility.
We strongly encourage you to proactively explore resources on self-defense law and mental health support available right there in your local area.
Making sure you're prepared for every single facet of self-defense